the organizers, for putting together this conference. I've looked around to see if anyone else is noticing that it's 75 years since the rape of Nanjing, and no one else seems to have noticed. So congratulations, in a sense, sadly, to you, Vic, for recognizing this is something we need to talk about. Perhaps there will be more recognition in the coming months. I want to talk about the Commission of Atrocities in War. I was going to talk more broadly in terms of address and redress. That is, how do you address the Commission of Atrocities, and how do you search for redress? And I'm not going to spend any time on address. I'm going to focus mostly on redress. By address, though, I mean, how do you acknowledge that it happened? How do you publicize that it happened? What demands are made for an accounting to be taken? How is this part of the public conversations that need to happen in the wake of atrocity? And this is something I think that, well, we're here today still addressing the in a sense, uncompleted legacy of Nanjing. But I don't want to talk about address today. I want to talk about redress. Redress usually comes in two forms, or that's how I will organize my thoughts here. One is financial redress, and the other is legal redress. And I'm not going to focus on financial redress either. I'm going to look narrowly at legal redress. That is, how do you, when an atrocity occurs, what do you do in terms of legal process? Now, to do this, I'm going to pose a couple of general questions in the beginning, and then I'm going to look at a particular document from the 19th century that is the foundation for all subsequent legal work on atrocity. Then I want to move to the Nuremberg and Tokyo trials, and in fact, Professor Wakabayashi has already kind of set that up very conveniently for me. And then at the end, ask the question of what does atrocity, and how can international law address atrocity? Let me start with a simple question, and it's a question that I don't know that I can answer, and I think the world is still trying to answer it, and that is, when atrocities occur, does law apply? Is law an appropriate, adequate, or necessary forum in which to deal with the commission of atrocity? I think we'd all say, well, yes, there's no question here. But I'm a historian, so I look back to an earlier time. If we go back to the 18th century, it wouldn't have occurred to anyone in any culture, anywhere in the world, that the commission of atrocities during the war deserved any kind of judicial redress. This is what happened in war. When the war was finished, the war was over. Whatever happened during the war was not judicially actionable. This begins to change in the 19th century. And the idea, it changes very slowly, but the idea begins to emerge, and the practice begins to emerge, of making people responsible for some of the acts carried out during the war. We've now, just in the last decade, moved into a very different phase. I don't know if we'll ever get to the point in which we are going to claim that all acts committed in the war are judicially actionable. But we are certainly beginning to expand the range of acts during the war that we feel can be brought before a court of law. This has only had a history of about 150 years. We are very early on in this history. And if we were to meet again in 200 years, I think we'd be stunned by the way in which the global international legal system had changed. Unfortunately, none of us will be here, and we have no idea what it's going to look like. But the place I want to start is, let me see, how far can I retreat? I'll retreat over here. There we go. The place I want to start is a code that Abraham Lincoln commissioned General Lieber to draw up in 1863, called the Lieber Code. I'm curious to know, has anyone in this room ever heard of the Lieber Code? Well, my undergraduate student has heard of the Lieber Code, so he gets extra points for this one. The Lieber Code is the beginning, it's the first attempt to draw up a full document on what constitutes lawful and unlawful actions during war. It's a remarkable document. I forget how many articles. It goes to 80 or 100 articles. It's a very long, thorough document. Not unsurprisingly, it emerges in a Civil War context. And I think that's why it emerges, because when you've got, in this case, Americans fighting Americans, there's a peculiar consciousness of the fact that you can't dismiss the other side as insects or vermin or however sides are characterized during war. You have to recognize the fact that Americans are killing Americans. This then calls into play the possibility that you need to actually treat each other according to some kind of rules. And so I've just put up a couple of the articles from the Lieber Code that begin to define the idea of legality in war. So Article 56, a prisoner of war is subject to no punishment for being a public enemy, nor is any revenge wreaked upon him considered legal. You cannot cause suffering, cruel imprisonment, want of food, and so forth. This is the first clear legal statement of the rights of a prisoner of war. I'll pass on 57. Article 60, it is against the usage of modern war to give no quarter. Professor Wakabayashi used that phrase, giving no quarter. It's seen in 1863 as barbaric practice. It's also understood, however, and it goes on in this article to suggest there may be emergency situations in which it is impossible to give quarter. But according to the rules of war, you have to give quarter. And troops that give no quarter, Article 61, have no right to kill enemies already disabled or prisoners captured by other troops. So large rights are written into law here for prisoners of war. Finally, Article 67 allows for the legality of war. We won't worry about that. But Article 67 says you can wage war, but 68 says the killing of the enemy should never be the object in war. And this, for many people, is completely counterintuitive. Of course, you have a war, you're going to kill people. But no, that is not what war is. So it's an extraordinary document. It's worth reading today because we're still struggling with a lot of these various issues. And then Article 71, a further protection saying you are not allowed to wound or kill somebody who is already disabled. All right, those are the, I'm going to go past Calabria. That lays down the first attempt to draw up a kind of legal framework for war. There are then meetings in The Hague and Geneva starting in the 1890s, going all the way through the 20s, in fact, continuing through much of the 20th century. Meetings at The Hague and Geneva to try and nail this down on an international stage. That is, take the Lieber Code, which is very much a national code for a national situation, and move it out onto the international stage. And it's not easy to do, for the simple reason that law is a national process. International law, in some sense, does not exist. International law only exists to the extent at which nations are going to subscribe to international law. And as Professor Blue said in his talk, you can draw up these agreements, people can sign them, but they might not ratify them, they might withdraw from them. So it means that international law has very little with which to work. It has to work through the state. And as long as the state is the agent through which international law works, you've got a big problem, because states are the entities that go to war. So it's a kind of an irresolvable contradiction through the 20th century. One of the ways to try and get at it was to draw up new rules for this sort of thing at Nuremberg and Tokyo. I won't dwell on the Nuremberg trial, but I will just put up this famous Article 6 in the charter of the International Military Tribunal, which defines these three categories: crimes against peace, war crimes, and crimes against humanity. Crimes against peace were very appealing in a kind of post-collective security vision of the sort that Professor Blue described for the 1920s. To my knowledge, nobody was actually executed on crimes of the first category. The second category, war crimes, these are standard categories that we would know, but the phrasing here is very vague. Violations of the laws or customs of war. Well, there aren't a lot of laws of war other than the Lieber Code, and customs of war are useless in a court. The Nuremberg Tribunal and Tokyo and the B and C class courts as well, they could easily wrap their heads around war crimes. The killing of prisoners of war, misconduct, mistreatment, that's pretty clear. Crimes against humanity is the new category that opens up here. And it's an attempt to try and deal with the problem of the terrorizing and destruction of civilian populations during war, for which the Lieber Code is no use. The Lieber Code is how soldiers deal with soldiers. It doesn't tell you how soldiers are supposed to deal with civilians. So Nuremberg is trying to say, all right, we have this idea of war crimes. How can we extend this in order to protect civilians in time of war? The Tokyo trial here we are moving to the Tokyo trial. The Tokyo trial takes on basically the Nuremberg architecture. When it comes to drawing up the indictment, it's a much more complex and in some ways overly specific series of counts that are put in the indictment. It's a much more thorough indictment than the Nuremberg indictment, and therefore in some ways it gives the bench more room in which to work to make their decisions, but it also sort of clouds the process and made it judicially a little bit obscure at times. But at any rate, I wanted to mention count 45. As you can read, on the 12th of December 1937 and succeeding days, by unlawfully ordering, causing, and permitting the armed forces of Japan to attack the city of Nanjing, and so forth. That this is Nanjing is written into the indictment at Tokyo. Curiously, General Matsui is not indicted under this count. And I have not done the research to understand why he was not indicted under count 45. In fact, perhaps Muto was, but I'm not sure if anyone else was. But then the real innovation, and Professor Wakabayashi has already talked about this, is the last three counts. These are crimes against humanity. Participating in forming a plan of war, ordering, authorizing, and permitting the commission of offenses in count 54, and then count 55, deliberately and recklessly disregarding legal duty to take adequate steps to secure the observance and prevention and to prevent breaches thereof. So 54 is the commission of war crimes, and 55 is the omission of war crimes. And 55 is the article that Nuremberg doesn't have. Nuremberg understands that you can be indicted for crimes against humanity that you commit, but not for crimes of humanity that you omitted to prevent. So this is it's a big step forward, and in fact, it's largely count 55 that has enabled the courts in The Hague since the 1990s to formulate some kind of a legal backstop for carrying out the cases against people in the former Yugoslavia and Rwanda conflicts. So this is the if you like, the international legal community trying to move forward to the idea that there is lawfulness in war, and that the lawfulness of war includes complete protection, or as much protection as possible for civilians. So, and again, I'm repeating what Professor she said, but General Matsui is, he's indicted on, let's see, 7 crimes against peace and 2 crimes against humanity. That is, he's indicted against, on 54 and 55, committing and omitting. The court finds him guilty, however, only of 55, not of 54. So in the opinion of the tribunal, Matsui did not commit war crimes. He failed to prevent the commission. He failed to prevent the commission of war crimes. For that, he is indicted, and for that, he is executed. The second person who is also indicted in this regard and found guilty is Hiroto Koki, the foreign minister. In his case, he's indicted on, I don't have the exact number, something like 6 crimes against peace and 2 crimes against humanity. And he's found guilty under 2 crimes against peace and number 55 as well. So count 55 is kind of this last, I called it a backstop early on. It's kind of a last point that the bench could use, although this actually, perhaps I should phrase it differently. It's the last point, sort of the last argument that the prosecution can bring forward to find a war criminal guilty when a reasonable defense reasonably allows acquittal on the other counts. And I think the thing that has to be remembered is that this is a court. Courts are not truth-finding commissions. The truth has, well, I'm going to say the truth has nothing to do with the judicial judgment. That's not quite true. But judicial judgments are based on conforming to a set of rules and procedures. And if you can't, using those rules and procedures, get to a guilty verdict, then you can't have a guilty verdict, even though someone may be guilty. I mean, this is the classic conundrum of the court of law. So count 55 is the way to kind of the last possible way of trying to catch a war criminal. And it works in these 2 cases. There was some international outrage about Hirota being found guilty of 55, because as foreign minister, he was receiving reports from Nanjing, from the consulate. He was conveying these reports to the cabinet, but nonetheless, he was found guilty. And some of the, anyway, other people in the diplomatic world felt that Hirota was being unfairly, that he should not, 54 and 55 should not have been part of his indictment. He is not executed, but dies in prison, I think, in 1948. So, where have we gone since 1948? The essential problem here with international law hasn't gone away. And the problem is this, and in fact, to express the problem, I'm going to quote someone who is buried in Yasukuni Shrine, and who is in Japanese. It's Radhabini Pal, who was the Indian justice on the Tokyo Tribunal. And in a lecture he gave in 1954, he said, recognition of the individual human being as the ultimate subject of international law would mean a fundamental change, and would require fundamental changes in the behavior of present-day powers. One other quote from the same speech. He said, as yet, international society has not made any progress towards making the individual the ultimate subject of international law. So what's he saying here? He's saying that international law cannot reach people. International law is law governing the relations among states. So if you think of international law up here, or international society somehow existing up here, and you have ordinary people, the people who died in Nanjing down here at the bottom, there's something in the middle, and the thing in the middle is called the state. And as long as you have the state as the only entity that international law can address, you're blocked from gaining access to and providing a judicial recompense for ordinary people. It's a real conundrum that international law is still struggling with. So those who argue that the rape of Nanjing was not subjected to judicial scrutiny, I think are on somewhat of a weak ground. This doesn't say that the rape of Nanjing has not been fully addressed, but it has met with the legal redress that it can get. But there is no other way to get to the victims by judicial means. There never will be another way to get to the victims by judicial means, in part because everyone who committed those crimes, with the exception of a small handful, is not alive today, and therefore cases cannot be brought against them. So I'm going to leave you with a provocative comment. Actually, I could leave you with lots of provocative comments. I will leave you with one provocative comment, and that is my concern. I have the luxury or the privilege of being neither ethnically, emotionally, or nationally related to the combatants on either side of this conflict. And from the point of view of some Chinese and some Japanese, that gives me no position in which to speak. But as a member of the international society up here, who deeply regrets what happens to ordinary people down here, I would say that today the problem continues to be the state, and that Chinese and Japanese who continue to conduct activist actions in order to raise the temperature and inflame public passions are seeking to dismantle the world order that the rest of us are trying to create. Thank you.